Good morning and welcome to this webinar hosted by BCL Legal. My name is James Quinn and I'm a solicitor and director in the dispute resolution team at Turner. Contracts can come to an end in a number of different ways, for example by frustration or following a force majeure event which may be stipulated in the contract, upon the expiry of a fixed term of the contract, or by subsequent agreement. In this morning's session, we'll be looking at bringing contracts to an end by termination. Since it's very common for contracts to contain an express termination provision, I will spend much of this morning's session looking at matters relating to these clauses, and in particular termination in the event of a breach by a party. We'll also look at termination for convenience and some cases to be aware of in the context of those clauses. I'll also look briefly at rescinding contracts at common law. We'll also look at terminating a party's rights and their rights to damages against the counterparty following a contractual termination or rescission at common law. I'll speak for just over 25 minutes, leaving a few minutes at the end for any questions. It's important to bear in mind at the outset that a party's right to terminate will depend entirely upon the precise terms of the contract and upon the facts and circumstances which have arisen, which may potentially give rise to a right to terminate the contract or rescind at common law. The principles established by the cases which we'll come on to consider, of course, all turn on the terms of their contracts and facts. Nonetheless, they should provide helpful general guidance when you're faced with a request for advice from your commercial colleagues and stakeholders on whether the company may terminate a contract validly. In each case, it will be essential to consider the termination provisions and the provisions of the contract as a whole extremely carefully, and consider whether you may terminate or rescind the contract lawfully in the circumstances which have arisen. If the termination or rescission is subsequently challenged by your counterparty, and it is later determined that the termination was unlawful, this may give rise to a claim for damages for your counterparty. Contracts frequently contain express rights to terminate, whether for one or both parties. These termination rights are not always based upon a breach of the contract by one party, and instead the trigger may be an event which is not necessarily a breach. For example, in many contracts, the identity of the counterparty may be of critical importance, and the contract may allow a party to terminate in the event of change in control or ownership of the other party. Depending upon the wording of the clause, it is not always straightforward to determine if, in fact, whether a change in ownership or control has occurred, and whether therefore an entitlement to terminate has arisen. A party may require certain licenses or consents in order to perform its obligations under a contract. It will often be the case that the contract will provide that the other party will be entitled to terminate in the event that those licenses or consents have been withdrawn or revoked. Contracts will often provide a right of termination in the event of the insolvency of the other party. Under English law, the position concerning rights to terminate in the event of insolvency has been complicated recently by the Corporate Insolvency and Governance Act 2020, which we'll come on to look at later. Contracts will frequently provide that one or either party may terminate the contract in the event of some form of breach. The precise form of wording will vary from contract to contract, perhaps referring to a material breach, substantial breach, or even any breach. We'll look at some cases involving the termination clauses referring to different descriptions of the breach. First, let's look at a case in which the termination clause provided for termination in the event of a material breach. In the case of Dalkia Utilities and Celtec, Dalkia was a company engaged in the design, construction, funding, installation, commissioning and operation of energy plants. Celtec was a subsidiary in a group of UK companies involved in the paper industry. Dalkia was constructing a new paper mill and entered into a number of agreements with Celtec, which would provide energy services to operate the mill. One of the agreements was a principal agreement, pursuant to which Dalkia was to provide the energy plant for Celtec and to provide certain energy services for a 15-year term. Celtec was to pay Dalkia 12 monthly instalments each year during the 15-year term of the agreement. As we see on the slide, the agreement contained a termination clause which provided that if Celtec was in material breach of its obligations to pay, Dalkia had the right to terminate the agreement immediately. Celtec failed to make 3 instalment payments under the agreement, amounting to £390,000, claiming it had no money, and it tried to renegotiate the terms of the agreement. Dalkia proceeded to terminate the agreement and relying on clause 14.4 and asserting that there had been a material breach by Celtec, and brought proceedings for the sums owed. In the proceedings, Celtec argued that the breach wasn't material as it concerned only 3 instalments out of 174 over a 15-year period. Dalkia's position was that a material breach was any breach which was more than trivial or which was not immaterial. Mr. Justice Clark in the Commercial Court held that there had been a material breach by Celtec in failing to pay the 3 instalments. As you see on the slide, the judge concluded that the sums involved were neither trivial nor minimal, and that Celtec's continued failure to pay them was serious. The judge remarked that when looking at the materiality of any breach, you have to consider the circumstances in which the breach has arisen. The judge's view was that this clause was intended to protect Celtec where the breach was only minimal, inconsequential, or inadvertent. At the same time, it would allow suppliers such as Anglia not to be out of pocket for a prolonged period, particularly in the context of a suggestion by Celtec that it was unable to pay. It's interesting to note that whilst the judge found that Celtec was in material breach under clause 14.4, it had not repudiated the contract as there had not been a breach of a condition, and that its present inability to pay did not deprive Anglia of substantially the whole of the benefit of the contract. And this is a good example of where an express termination right will come to the benefit of the innocent party, where the same circumstances would not allow that party to rescind the contract at common law. The case is also a helpful illustration of the court's approach to assessing what will amount to a material breach, and which will depend upon the precise wording of the termination clause and the surrounding facts and circumstances. One sometimes sees contracts giving one or both parties the right to terminate in the event of any breach of the agreement. Such a clause, of course, appears to be very widely drawn, and the question arises whether a party can indeed terminate lawfully in the event of absolutely any breach of the agreement. This has been considered in previous cases, and we'll look at some examples. First, in the Antineus, an arbitration tribunal was determining claims between ship owners and charterers under a 3-year time charter party for the use of the vessel, the Antineus. The withdrawal provision of the charter party allowed the ship owner to withdraw the vessel from hire and effectively bring the charter party to an end for any other breach of this charter party. The arbitrators found that any other breach of this charter party meant a repudiatory breach or a fundamental breach of an innominate term or breach of condition, and not just any breach. The arbitral award was appealed all the way to the House of Lords, the House of Lords agreeing with the arbitrators on this point. As we see on the slide, the court remarked that if a semantic and syntactical analysis of words in the contract would lead to a conclusion which flouts business common sense, then it must yield to business common sense. In Rice and Great Yarmouth Borough Council, the council had entered into 2 contracts with Mr. Rice for the provision of leisure management and grounds maintenance services for sports facilities, parks and gardens in the town for a 4-year term. As we see on the slide, the trigger for termination by the council was stated to be a breach of any of its obligations under the contract. The council raised various complaints about the condition of the facilities and purported to give notice to terminate the contracts. The trial judge found that the contracts had not been terminated lawfully and awarded damages to Mr. Rice. The council appealed to the Court of Appeal. It argued that the termination clause should be applied literally to give them the right to terminate for the breach of any of the obligations in the contract except for trivial breaches. The Court of Appeal rejected this argument. As we see on the slide, the court pointed out that the termination clause did not characterize any particular term as a condition or indicate which terms were so important to justify termination. And the Court of Appeal held that the suggestion that the council could terminate any breach of any term flies in the face of commercial common sense. The council ran an alternative argument that the totality of the contractor's individual breaches justified the termination of the contracts. The trial judge had considered the breaches and concluded that even cumulatively, the breaches cannot be said to have deprived the council of the whole benefit of the contracts. The Court of Appeal also dismissed this argument from the council, and it held that the trial judge was entitled to reach this conclusion. So again, we see the court taking a restrictive interpretation to the concept of termination for a breach of any obligation and not allowing a party simply to terminate for any breach. We turn then to the last case on this point, which is the case of Dominion Corporate Trustees and Debenham Properties. This case concerned a lease agreement entered into between the parties. The lease contained a termination provision which provided that if either party shall in any respect fail or neglect to observe or perform any of the provisions of this agreement, the other party could give notice to terminate at any time after the occurrence of the default. Dominion was obliged to pay Debenhams £50,000 within 5 days of the agreement, a further £425,000 within 10 days of completion of certain works, and a further £425,000 within 10 days of the opening of the premises for permanent trade. The first £50,000 was paid. The first £425,000 was then not paid, following which Debenham served notice stating it was terminating the agreement under Clause 19. Dominion asked Debenhams to accept payment of the £425,000 late, but Debenhams refused and maintained that the agreement had been terminated. The judge considered the Anteos case and the Great Yarmouth Council cases, and as we see, accepted as a starting point that without taking account of the context and relevant background, the wording of Clause 19 could be understood to mean that there was a right to terminate in the event of a failure to perform any provision of the agreement. However, the judge held that such an interpretation was not appropriate. He concluded that a reasonable commercial person would understand Clause 19 to mean that there would have to be a repudiatory breach in order for the innocent party to be entitled to terminate under this clause. It seems clear from these cases, therefore, that despite what on the face of it is a very wide form of wording referring to any breach of the agreement or a breach of any obligation in the agreement, that the court is unlikely to find that a party may terminate for simply any breach, and that a breach of a condition or some form of repudiation is likely to be required. It would therefore appear to be a very high-risk strategy indeed to terminate or seek to terminate based upon the breach of just any breach, including a trivial breach of an agreement. In some contracts, the parties will agree for one or other of the parties to be entitled to give notice to terminate the contract for convenience and without any breach by the other party. This is not uncommon in construction contracts, for example, with the client or employer being entitled to terminate the agreement at its own choosing. Usually the contract will set out the obligations and steps which must be followed after this right has been exercised and how the contract is to be wound down. So in the absence of any express obligation for a party to act in good faith when invoking a termination for convenience clause, is a party under any duty of good faith when exercising this right, or are there any restrictions preventing this right being exercised? Let's look briefly at two cases. First, in TSG Building Services and South Anglia Housing, the parties entered into a contract under which TSG was to provide building and maintenance services to South Anglia's housing stock. Clause 1.1 of the contract provided that the parties were to act in the spirit of trust, fairness, and mutual cooperation, and reasonably and without delay. Clause 13.3 allowed the client, South Anglia, to terminate the contract at any time following the 4-year term of the contract. A little over a year into the contract, and after having expressed some disappointment about TSG's charges, South Anglia served a notice terminating the contract under Clause 13.3, with the termination to take effect 3 months later, although it had not made clear precisely why they had chosen to terminate. The issue for the court to decide was whether the termination under Clause 13.3 of the contract needed to have been effective either reasonably on the proper construction of the contract or in good faith by implication. On the construction point, because the question was whether the right to terminate in Clause 13.3 was constrained by Clause 1.1 and its reference to acting reasonably. In applying the established rules on construing contracts, the judge concluded that on a proper construction of Clause 1.1, there was no obligation on South Anglia to act reasonably when exercising the right to terminate under Clause 13.3. In other words, the reference in Clause 1.1 to the parties acting reasonably did not apply to the termination right in Clause 13.3. Clause 13.3 amounted to an unqualified and unconditional right to terminate. Having considered the authorities on implying terms into a contract, the judge concluded that there should be no implied term that a party exercising the right to terminate under Clause 13.3 should act in good faith. As we see, the judge held that even if there was some implied term of good faith, it would not and could not circumscribe or restrict what the parties had expressly agreed in Clause 13.3, which was in effect that either of them, for no good or bad reason, could terminate at any time before the term of 4 years was completed. Looking then at a second case of Mond Petroleum and Western Zagros, Mond Petroleum had entered into a 4-month consulting agreement with an oil and gas company, Western Zagros. Under the agreement, Mond Petroleum was to provide consultancy services and lobby the government of Kurdistan to secure oil contracts for Western Zagros in Kurdistan. Mond Petroleum was to receive a fee equal to 3% of the interest in the contracts, ultimately secured by Western Zagros. The contract contained termination provisions, and shortly after securing an oil contract with the Kurdistan government, Western Zagros terminated the contract with Mond Petroleum. The parties concluded a termination agreement under which Western Zagros was to pay $700,000 to Mond Petroleum. Mond Petroleum later argued that this sum had already been due to it, that it had been induced to enter into the termination agreement, following misrepresentations by a third party on behalf of Western Zagros. One of the issues to be determined was whether it was an implied term of the contract that Western Zagros would not exercise the right to terminate in bad faith. The judge began his analysis of this question by remarking that there is no general doctrine of good faith in English law, although he recognised that a duty of good faith is implied into certain contracts, such as employment contracts, contracts between partners, or others in a fiduciary relationship. Turning then to whether a term should be implied into the contract that the right to terminate should not be exercised in bad faith, the judge concluded that there was no such implied term. The judge considered that the right to terminate could be exercised whatever the reasons the terminating party had for the termination, and it did not need to justify the termination. So we've seen that with what might be described as an ordinary commercial contract, the courts have not been prepared to imply an obligation that a party must act in good faith when exercising its right to terminate a contract for convenience. But is this the case with other types of contracts? In the Bates and Post Office case, which we'll look at now, the court considered the lawfulness of the termination of contracts in the context of relational contracts. The Bates and Post Office case was a piece of group litigation between 550 sub-postmasters in the post office. The background to the case is that the sub-postmasters brought claims arising from the alleged defects in an electronic accounting system, which had apparently led to accounting shortfalls. The post office maintained that the sub-postmasters were liable for these shortfalls, but the postmasters blamed flaws in the accounting system. Some of the sub-postmasters had to pay shortfalls despite disputing them. Some had their contracts terminated, and some even had received criminal convictions. The aspect of the case which I'd like to focus on today was the court's decision that the relationship between the post office and the sub-postmasters amounted to a relational contract. In contrast to the TSG and Mon Petroleum cases which we've just looked at, and which dealt with ordinary commercial contracts, in the post office case, the court found that an obligation of good faith was implied in a relational contract. This meant that the parties had to refrain from conduct which would be regarded as commercially unacceptable by reasonable and honest people. This involved more than the requirement to act honestly. Transparency, cooperation, and trust and confidence were, in the judge's view, implicit within the implied obligation of good faith. However, it did not mean that there would be an implied duty of good faith in all commercial relationships. We therefore need to try to identify if we're talking about a relational contract to know if this is an issue that needs to concern you. The judge set out a long, non-exhaustive list of characteristics that were relevant in deciding whether a contract was relational. The first of these was determinative, that there had to be no express term preventing the duty of good faith from being implied. If there was no such clause, then the following were relevant in assessing the circumstances of the relationship in its commercial context, but none were determinative. These were, as we see, whether the contract was a long-term contract with the mutual intention of a long-term relationship, whether it was the intention of the parties that roles would be performed with integrity and fidelity, whether there was a commitment for the parties to collaborate in performing the contract, and whether the spirit and objectives of the venture were incapable of expression in a written contract. The list continues, and so whether the parties are reposing trust and confidence in one another, but of a different kind to that involved in fiduciary relationships, whether the contract in question involves a high degree of communication, cooperation, and predictable performance based on mutual trust and confidence and expectations of loyalty. There may be a degree of significant investment by one or both parties. The judge said that this might be more accurately described as substantial financial commitment. Lastly, exclusivity of relationship might be present, and the judge found that all these features were present in the relationship between the post office and the postmasters. He emphasised that accepting that these contracts were relational did not mean that there would be an automatic and widespread application of an implied duty of good faith to all commercial relationships. Very specific characteristics are needed to categorise a commercial contract as a relational one. And the implications of the duty in this case were wide, but for present purposes, I'm only going to focus on what this meant for the post office's right to terminate the contracts. There were two contracts that the court needed to review in relation to the question of termination. The first provided that the post office could terminate on giving not less than 3 months' notice. The judge found that the period of notice had to be a minimum period of 3 months. It did not mean just 3 months. The post office had to consider what the appropriate period of notice should be, and they had to give some conscious thought to that decision. They could not simply arbitrarily decide that 3 months was appropriate. The consideration had to be undertaken in compliance with the duty of good faith and take into account only relevant factors and not irrelevant ones. The second contract had a notice period of not less than 6 months. The judge said that if the words "not less than" were to have some meaning, then there must be a process of decision by the Post Office. And construing these words in their contractual commercial context meant they could not be construed as meaning exactly 6 months. So whilst the implication of a duty of good faith will still be very limited, it is beginning to be applied. And there is a possibility that long-term agreements could potentially fall within the definition of relational contracts in appropriate circumstances, but as ever, there are likely to be grey areas. We'll now look at a more recent case on this point from last year. It concerned a long-term PFI contract entered into in 2012 between Essex County Council and its contractor UBB Waste for design, construction, commissioning, operation and maintenance of a mechanical biological waste treatment plant. The plant was to be used for the processing of household waste. During the commissioning phase of the works, the plant failed a series of acceptance tests on the performance of the plant. UBB put forward a series of suggested steps to overcome the performance issues with the aim of passing the acceptance tests. However, this was unsuccessful. The contract contained a termination clause allowing the council to terminate in the event of a contractor default by serving notice on UBB. In light of the failure to pass the acceptance tests, the council considered that UBB was in default and it served a notice to terminate the contract. UBB disputed the termination, insisting that it was not in default. Instead, it blamed the acceptance test failures on the waste that had been processed at the plant. The judge found that UBB was in default due to its design of the facility and which had caused problems with the performance of the plant. Accordingly, the council was entitled to terminate under the termination clause. UBB had argued that the contract was a relational contract and that there should be an implied term that the council was to act in good faith in connection with the acceptance tests. However, the judge was satisfied that this was indeed a relational contract. In concluding that this was a relational contract, the judge was guided by the considerations in the Post Office case. In addition, he cited other factors which led him to this conclusion, and this included the long-term nature of the contract, the close collaboration required by the parties, high degree of communication and cooperation, the significant investment required, and the exclusivity between the parties. The judge found that there had been no breach of the obligation of good faith by the council. He ruled that whether a party has not acted in good faith is an objective test, and that whilst dishonest conduct would be a breach of the duty of good faith, dishonesty was not of itself a necessary ingredient of an allegation of breach. His view was that the question is whether the conduct would be regarded as commercially unacceptable by reasonable and honest people. He emphasised that the requirements for a breach of the obligation of good faith would depend on the contract and on the background facts. I expect that the law in this area will continue to develop and evolve, and I suspect that we're likely to see more parties seeking to argue that their contracts are relational if they want a duty of good faith to be implied. When faced with a decision on whether or not to terminate a contract, consideration should be given to whether your contract is a relational contract, which may potentially be subject to an implied duty of good faith, and whether there could be any suggestion that you may not have acted in good faith when seeking to terminate. Earlier, I mentioned clauses which allow a party to terminate the contract if the other party becomes insolvent. Following the impact of the COVID-19 pandemic on businesses, in May last year, the government introduced the Corporate Insolvency and Governance Bill, and the Corporate Insolvency and Governance Act 2020 subsequently came in force on 26th of June last year. The purpose of the Act is to make temporary changes to ease the impact businesses face following the national lockdowns, and to make provision about companies and other entities in financial difficulty, and to make temporary changes to the law relating to the governance and regulation of other entities. The Act applies to all contracts for the supply of goods and services, but excluding banks and other financial services providers. There are a number of changes which relate to insolvency proceedings, but today I wanted to briefly touch on a permanent change to Section 233 of the Insolvency Act 1986. The Corporate Insolvency and Governance Act introduced Section 233B of the Insolvency Act, which applies to the exclusion of termination clauses in supply of goods and services contracts. As I mentioned earlier, it is common for commercial contracts to contain an express provision for termination in the event of insolvency, and which allows a party to threaten to terminate their supply of goods or services if the company enters into insolvency proceedings. Section 233B of the Insolvency Act provides that if the company becomes subject to a relevant insolvency procedure, and there is a clause in the contract giving the right to terminate in the event of insolvency, that provision in the contract ceases to have effect and is overruled by the Act. The relevant insolvency procedures are defined at Section 233B2 of the Insolvency Act and include liquidation, voluntary arrangement, administrative receivership, and a new moratorium administration, which was introduced by the Corporate Insolvency and Governance Act. Supply contracts will therefore need to continue even if the customer has entered into the relevant insolvency proceedings. However, there is some comfort that insolvency termination clauses can still be relied upon, but only in the following circumstances. Firstly, where the office holder, for example, the administrator, the administrative receiver, liquidator, or provisional liquidator, consents to the termination of the contract, or the company consents to the termination of the contract, or if the court is satisfied that the continuation of the contract will cause the supplier hardship and grants permission for the termination of the contract. It's therefore worth reviewing your contracts to understand if you have a clause permitting termination in the event of insolvency and how this new act may impact upon those contracts. Even though it is possible that the clause may be void, the clauses should still remain within the contract to ensure that they can be relied on if necessary. For example, if an application was made to the court or to the officer holder of the company, if they consent to the contract being terminated. We frequently see contracts in which there is an express right to terminate the contract together with provision which preserves the party's ability to rely on common law rights to rescind the contract. Even without such express wording, the parties will still be able to rely on the common law right to rescind unless there are clear words in the contract which exclude those common law rights. We'll recap very briefly now on the right to rescind a contract at common law. This is separate from a contractual right to terminate, pursuant to an express termination clause which may be included in the contract. As we've just seen, if these rights are to be excluded, there will need to be clear words to provide for this. So in brief, a contract may be brought to an end at common law if following a repudiatory breach by a party. First of all, this could be by a breach of condition. A condition is a clause, provision which goes so directly to the substance of the contract or are essential to its very nature that their non-performance may be fairly considered by the other party as a substantial failure to perform the contract at all. A warranty is a term of lesser importance than a condition, and a breach of warranty will not entitle the innocent party to rescind the contract. An intermediate or a nominate term is again of lesser importance than a condition, but a serious breach may potentially allow the innocent party to rescind a common law. This will be a question of proper construction of the contract and the precise facts and matters which have arisen. Alternatively, the other party may repudiate by refusing to perform or depriving the innocent party from the essential benefit of the contract. The innocent party may elect to affirm the contract and call upon the counterparty to continue to perform. Alternatively, the innocent party may elect to accept the counterparty's repudiation of the contract as bringing the contract to an end and claim damages. A key distinction between terminating pursuant to a contractual termination provision and rescinding at common law is the damages which may be awarded to the innocent party. When terminating pursuant to a contractual termination provision, the innocent party can claim damages for any losses suffered up to the date of termination. However, importantly, when rescinding at common law following a repudiation by the other party, the innocent party may claim damages for losses up to the date of rescission and also for loss of bargain damages relating to the future value of the contract. To finish, we will look briefly at a case in which the innocent party had the choice of whether to terminate under a contractual termination clause or a common law. In Phones for You and EE, Phones for You claimed £120 million from EE for unpaid sums due under trading agreements. EE counterclaimed for £200 million of damages arising from alleged repudiatory breaches of trading agreements by Phones for You. The timeline was as follows. On the 12th of September 2014, EE notified Phones for You that it would not renew or replace the trading agreements between the parties when they expired. That afternoon, Phones for You resolved to appoint administrators. In the morning of 15 September, none of Phones for You retail outlets and shops opened for business. In the afternoon of 17 September, EE sent a termination notice to Phones for You referring to clause 14.12 of the contract, which allowed them to terminate immediately upon Phones for You taking any steps to appoint an administrator. The important points to note here are that EE's termination notice referred only to exercising its no-fault contractual termination right. Although it later sought to argue that Phones for You was in repudiatory breach because it could not perform the contract, nowhere did the notice of termination purport to exercise the common law right to terminate the repudiatory breach. The judge found that reserving rights or not waiving any other breaches is passive and that a reserved right is not an exercised right. In essence, EE did not terminate the contract for repudiatory breach. The contract had already been brought to an end before EE purported to accept a breach of the trading agreements as giving rise to their loss of bargain damages claim. It was therefore not entitled to claim loss of bargain damages, and its claim to do so was defeated by a summary judgment application. The case highlights the importance of thinking through the termination options available to you before serving notice, and in particular, what the consequences might be if you decide to exercise a contractual termination provision rather than relying on a common law right to accept a repudiatory breach. If you want to seek to claim loss of bargain damages, you must clearly communicate that you're accepting a repudiatory breach of contract in your notice of termination, rather than reserving your rights and using a no-fault termination provision. So to sum up then, when facing a decision on whether to terminate a contract, it is essential to consider extremely carefully the termination provisions of the contract as a whole, and the surrounding facts and circumstances to conclude whether you may terminate validly or whether there is a risk that any termination may later be found to be unlawful. If your counterparty challenges the termination successfully, you may later face a claim for damages for unlawful termination. A clause permitting termination for any breach is likely to require serious breach, although as we saw in the Dalkia case, the breach in question was less than a repudiation. Extreme caution should be exercised with a clause allowing termination for any breach, and it is unlikely that a termination for simply any minor or trivial breach will be sufficient. The cases indicate that a breach at the level of a repudiation will be required. Depending on the particular wording, a termination for convenience may give you a wide discretion to terminate, although do bear in mind whether the contract is a relational one, in which there may potentially be an obligation to act in good faith when exercising the right to terminate for convenience. When dealing with a counterparty who is in some form of insolvency, consider whether any contractual right to terminate for insolvency may have been impacted by the Corporate Insolvency and Governance Act 2020. Lastly, be aware that following a contractual termination, you will generally be limited to claim damages for losses which have been suffered up to the date of termination, and not loss of bargain damages for the future value of the contract. And if you are bringing the contract to an end pursuant to a common law right, and not by exercising a contractual termination right, ensure that this is clear in your communication to your counterparty. So that brings the presentation to an end. And again, with my apologies for problems with the slides there. Do we have any questions?
Hi, James. Yeah, just following on from that, apologies there for the technical glitch. There are a few questions, but I just wanted to say for those watching that we will send the slides to the attendees today so that they can have the opportunity to look through them. There are a few questions, James, so what I'll do is I'll condense them, send them to you, and then you can reply personally to them via email, because I am conscious of the time. Okay,
I agree, that makes sense. So thank you everyone for joining, and again apologies for the technical issues with the presentation. Thank you.